Good morning, everyone. Thank you for joining us for today's presentation on LFOs. As Corey said, my name is Charlie Klein. I'm a staff attorney here with Civil Survival. So what I'm going to do is share a presentation sort of going through a background on what LFOs are, what the types of relief that are available, and then getting into some of the more recent changes in the law, including House Bill 1412, which recently passed this past session and will take effect January 1st of 2023. And then we'll touch upon the new GR 39 standardized forms, which are being used statewide. And my colleague Sugam Soni will go into a more depth look at those forms and how to proceed under that new rule. So if you'll bear with me, I'll share my screen here and we'll start the presentation. All right, everyone seeing that all right?
Yes.
Great. All right, so legal financial obligations, or LFOs for short. So what these are fees and costs, fines, restitution, any sort of assessment that's imposed as part of a criminal sentence. Okay, so throughout Washington state law, there are more than 100 types of LFOs, depending on the statute and depending upon the criminal offense. Most of these are discretionary, which means that the judge in the particular case has the authority to decide whether or not to impose them. Some are mandatory. Most of the mandatory fees that you will see are associated with felonies, and the biggest ones are a $100 DNA collection fee, which can be collected once for the first collection of DNA following a felony conviction, and then a $500 victim penalty assessment, which is imposed in every felony conviction. Finally, there is often restitution imposed where there is an actual injury or loss that has occurred. Okay, so LFOs have an extremely disparate impact. They disproportionately impact communities with high rates of poverty and communities of color. So in this example here, you see a map of the Seattle area, and you see a key here showing rates of poverty on this axis, rates of LFOs on this axis, with this dark shade indicating rates of high poverty and high LFOs. And so as you can see in this map, lo and behold, the areas that have high rates of poverty and high rates of LFOs also happen to track closely with the areas where communities of color are concentrated in the greater Seattle area. That is not a coincidence. That is how the system is designed. Furthermore, there are large county disparities within the state of Washington with regard to the imposition of LFOs. So while individuals with felony convictions in Washington usually carry an average LFO balance of around $2,540, there's no uniformity throughout the counties in the amounts imposed, in whether or not the courts examine the defendant's ability to pay, and how those fines are actually collected, and how the enforcement of those fines is doled out. Okay, so you may have one county that imposes the bare minimum of LFOs in every felony case. You may have another county that uses LFOs as a significant revenue source, and so therefore imposes quite a bit more in an effort to fund various county systems. It just varies widely between county. So what are these LFOs? What kind of barrier do these impose? Well, these LFOs, at least as of up until 2018, accrued interest at 12% a year from the date of judgment. Okay, so what that meant was if you had entered prison in April of 2011 with $2,000 in LFOs and you left prison in 2013, you had all of a sudden 2,800 in LFOs. Okay, so that 12% adds up quickly and just continues to compound, particularly since a large percentage of folks with LFOs are not able to afford to make large payments on those LFOs, if any. So if you're paying back $25 every month on your LFOs, the interest is going to quickly swamp, and make things the situation much worse than you're able to keep up with. Another barrier and thing that really keeps people locked in this debt is the fact that courts are authorized to use collection agencies. Okay, so these collection agencies can impose a fee of up to 50% of the balance under $100,000. They're also authorized to collect a collection fee of up to 35% of a balance over $100,000. In addition to these collection fees, they can also impose their own 12% annual interest. So you've got 12% interest from the court, you've got 12% interest from collections agencies, you've got collections agencies fees. You can obviously see these are going to add up quickly, particularly when you take into account the fact that folks with criminal records are going to have a harder time finding employment and thus are going to struggle to stay afloat with all this on top of them. Okay, now if you're unable to make those payments after release, you also face garnishment of your wages, you face warrants for non-compliance, and you can potentially face confinement if you're found to be in willful default. All right, but our goal at Civil Survival is to make those barriers fall. Now, under the old law, pre-2018, there were a number of avenues for relief. None of them were great. Okay, so for offenses that were committed after July 1st of 2000, you could seek waiver of the interest on your non-restitution. Okay, so any fines that weren't restitution. The court had to remove interest that accrued during your confinement. That meaning, when you were in DOC custody or jail, the court had to remove interest that accrued there. And the court had the option or the discretion to waive any other non-restitution upon showing that the payment created a hardship. Furthermore, the court had the discretion to reduce any interest on restitution, but that would only be in the case of someone who had paid the full court-ordered restitution principal. So if you had $500 in restitution ordered and it accrued a 12% interest, the only way to get that interest waived would be to pay off that initial $500 restitution. And that was for offenses committed after July 1st of 2000. Offenses committed prior to July 1st of 2000, when there was a law change, had a 10-year expiration date on their jurisdiction. So what that basically meant is that the default was that after 10 years, even if you hadn't been able to pay a cent, after 10 years of your release from confinement, the court no longer had jurisdiction to enforce LFOs on that case. Now, the prosecutor would always have the option of filing a motion to extend jurisdiction before the expiration of that initial 10 years. So you could end up with a total of about 20 years of jurisdiction. But as we're seeing now, most cases that were before July 1st, 2000, we're beyond 20 years from that point. So a lot of those cases, even if jurisdiction were extended, a lot of those cases, even under the old law, would be eligible to waive the entire balance based on the court's lack of jurisdiction. But as I said, this was under old law pre-2018. So in 2018, we had House Bill 1783. Okay, so 1783 basically codified or put into the Washington State statute previous case law. Okay, so what this statute did was it eliminated interest on non-restitution LFOs, and this was retroactive. So any interest that had accrued was now eligible for waiver, and it had to be waived. So whereas before the court only had to waive interest that had been accrued while you were in custody or in some sort of community custody, now the court had to waive all interest. Okay, so that was a big change and has done a lot to help folks relieve their LFO burdens. Furthermore, the court had to consider the ability of a defendant to actually pay before imposing LFOs. Okay, so no longer could they just impose the LFOs, without taking into consideration a defendant's ability to pay. And finally, the court had to waive discretionary costs for indigent defendants. So the court had to waive any discretionary LFOs if the payment imposed what was deemed a manifest hardship. So that was in 2018. So, while it was a great law change, there was still plenty of work to be done, and there still remains plenty of work to be done. So, avenues of change that folks are still pursuing. There is a Minority and Justice Commission, that the LFO consortium that is working together with various stakeholders to help guide future reforms. There is what we call impact litigation, or cases that are brought before the court and designed to move through the various levels of the court, from trial court to appeals court to state Supreme Court, to force a change in the law. And finally, there's future and ongoing legislation. For example, these two legislative changes we've seen in this past year, GR 39 and House Bill 1412. Okay, so House Bill 1412, which will take effect in January 1st of 2023, is a significant improvement on the law in a number of ways. Okay, so first, with regard to restitution, okay, which has always been a sticking point within LFOs. So now courts may waive restitution and accrued interest owed to any insurer or state agency. Okay, so if you are convicted and it's deemed that you owe insurance or owe restitution to an insurance company, or say like, the Department of Licensing, that restitution can be waived by the court. Whereas before, no restitution was mandatory no matter what. Okay. Furthermore, the courts at sentencing can choose to not impose restitution at all if they deem that there is no future or present ability for the defendant to pay that restitution. That's at sentencing. And finally, courts may waive or reduce restitution that accrued during your incarceration, restitution interest that accrued during your incarceration once you're released, if you have no future or present ability to pay. So that's a big difference. But that's similar to what the law was prior to the 2018 change with regard to non-restitution interest. Now they've sort of extended that to restitution. So, this bill is chipped away at this big barrier that restitution still imposes. Another big change is the enforcement period. So whereas before we talked about how those offenses prior to July 1st, 2000 had this 10-year jurisdictional enforcement period that could allow folks to get real relief if a number of years had passed, that enforcement period has been reapplied to non-restitution LFOs. So all cases, regardless of when the offense was committed, the non-restitution LFOs will have an initial 10-year enforcement period. Additionally, while that 10-year enforcement period can be extended by motion again, it will only be extended if a defendant is not indigent. So if a defendant is deemed to have the ability to pay, that enforcement period can be extended. However, if the defendant has no future or current ability to pay, the court's not going to extend that jurisdiction, and those LFOs are going to be entirely waivable within 10 years of release from confinement. Finally, another big change is that the definition of indigency, which is the sort of standard that the court looks at to determine if waiver is applicable, has been expanded to include persons who are homeless or mentally ill, and also persons who have recurring basic living costs that render them unable to pay. So before, indigency required you to either receive government benefits, some form of government benefits, or to have a gross income that was below 125% of the federal poverty guidelines. This standard now takes into account folks who may have an income that's greater than those poverty guidelines, which are like horribly, they're far too low to be inclusive of what poverty actually looks like. So this takes into account folks who are still making money than that very low, more money than that very low threshold, but are still unable to pay their costs. Okay, so the other big change was GR 39. Okay, so this was a change that basically standardized forms across Washington. We talked earlier about how processes vary from county to county, and Washington does not have a unified court system. So in an effort to fix and make this process easier and more smooth for folks trying to get relief, the legislature and the Supreme Court Rules Committee has taken some big steps to try to remedy that. So for this section, I'm going to turn it over to my colleague Sugam, and we will keep track of your questions in the chat. So I know we sort of moved through that pretty quickly, but we're happy to answer questions at the end. So for right now, I'm going to stop sharing my screen, and I'm going to hand it over to Sugam, if I can.
Good morning, everyone. I really appreciate everyone being here. I want to thank you for your time. Like Charlie mentioned, I work alongside Charlie as a staff attorney at Civil Survival. And I am going to go through the different GR 39 forms that the state has created for us to kind of make this process a little bit easier. I think Corey just added the link in the chat, which is the link to where you can go to for the standardized forms. I'm going to go ahead and share my screen here so you guys can see what that website looks like.
For folks viewing on Facebook, I've also just added the link to those forms there as well.
Great. So can everybody see this website? Right. So the link will take you to the Washington Court's website here, and this is court forms specifically for legal financial obligations. If you go back to the homepage here at the court's homepage, there are going to be forms that are available for a variety of other things, but today we're going to focus on the legal financial obligations. You'll see them listed out right over here, and there's the petition regarding legal financial obligations and the order regarding legal financial obligations. The petition is the actual motion that we file, which is the request for the court to waive or remit any legal financial obligations that are eligible. And the order is what the court normally fills out in response to our motion. We provide the proposed order just to make things easier for the court, but we don't fill out all of the information on there, and I'll explain that for you. So I'm going to go ahead and switch it over to the actual form, the petition itself. And now we should be able to see this GR39 petition, which is the main motion that we'll be filling out. I'm going to go through kind of how to fill it out. And if there are any questions, just go ahead and put them in the chat and we'll kind of run through them at the end. So basically, we're going to start off here at the top where is the heading, and you'll see an open space here. This is going to be for the type of court that we're looking at. Generally, the felony convictions are going to be in superior court. But sometimes you may be trying to waive legal financial obligation in district court where misdemeanors are, or municipal court where infractions and gross misdemeanors can happen. But for the most part, we'll be entering superior court in here. So we'll type in the superior court of Washington, county, city of wherever you are. For me here in Seattle, I'm just going to go ahead and put in county of King. We'll go ahead and delete city. So that's your basic header that you need for them. There's not much else that you need to do for the header. You'll put in the defendant's name right here, which is whoever the person is that's trying to waive legal financial obligations. You don't need a signature here, just typing in the name. And if you're printing this out, you can just write it out too. But you'll put in the name and date of birth here, obviously. The bottom two sections here for PCN, TCN. PCN, TCN is going to be parent country of national or temporary country of national, and that's going to be for someone that's a non-citizen. But generally, for a legal financial obligations remission case, we don't really fill out the PCN, TCN, or the lower one, which is the state ID number, because it's not really necessary. If you are a non-citizen, generally LFO petitions don't really have too much of a factor in your case, but even still, just because you are a non-citizen and there are potential legal consequences in your immigration, you should always consult with an attorney before you do anything with the courts. So you'll put your name and date of birth here, and then over here for the number will be your cause number, and that's the number of the case that you were involved in. Generally, you can find that on most of the paperwork. If you have access to any records, you can find that, but the easiest way really is to call the Superior Court Clerk's office in the county where the case is located, and you can get that information from the clerk as well. You'll put the cause number there, and with your name, date of birth, and the cause number, the court will be able to identify exactly who's filing this petition. We'll move forward here to the actual petition itself. You can see that this is a form to request your LFOs being waived by yourself. There are a bunch of different sections here, and I'll go through each one of them slowly for you. And the first one, essentially what we're doing is just checking everything that we are requesting. The first section is going to be for interest, and you can see that's check all that apply. And the first one will be waiving unpaid interest on LFOs that are not restitution. We can request that, as we know, if we're in our finding of indigency, we can request that we waive all unpaid interest on LFOs that are not restitution. So generally, we'll be clicking that if you have any LFO interest that's not restitution. The second box will be for the restitution interest itself. As Charlie discussed, if you've paid the principal of your restitution in full and all that remains is the interest, you can ask the court to waive or reduce the remaining interest as an incentive for you to pay off the remaining balance of your LFOs. And I will say that this is discretionary for the court. They don't have to waive the interest, but you make the argument that if you're finding that I don't have the ability to pay, it doesn't make sense for me to pay the interest. But generally in our practice, we found that once the restitution principal has been paid, most courts are pretty willing to go ahead and waive the interest as well. So if that's relevant to you, you can go ahead and check off that box as well. And the second one will be all LFOs that aren't restitution. So this will be, your non-mandatory LFOs that Charlie discussed the mandatory ones, but there are a wide variety of non-mandatory LFOs that can be imposed. You can get anything from just a public defender fee or a court collection cost or a variety of different things. But as Charlie mentioned, the mandatory ones are your one-time DNA collection fee, your crime victim penalty assessment fee, and any restitution that could be applicable. Other than that, everything else is waivable, which means the court has the discretion to go ahead and waive all other LFOs. We would be, if you're asking for your LFOs to be taken off completely, we would be asking for a remission or a reduction. You don't have to do anything more than just selecting that box. The court will know that you're asking for it to be waived. You can also select for additional time to get additional time to pay your unpaid LFOs, which the court will likely grant you anyways, even if they don't waive your balance off fully. And you also request for your LFOs to be removed from collection and waive all collection fees. The last part is community restitution. You can also request that any unpaid LFOs get converted to a balance that you serve in community service. You don't have to check this. It's my practice to not check it and wait to see what the court waives and doesn't waive. If the court ends up waiving a chunk of your LFOs, but there's still a remaining balance that you don't feel like you can pay, you can always ask them at a later time to convert that into community service as well. But generally, I try to focus on trying to ask them to waive it completely and not convert that balance into community service. Section 3 will be your declaration, a little bit of information about yourself. Mainly, it's going to be a finding of indigency, which is the finding that you qualify for, well, not necessarily qualify, just that based off of your financial circumstances, you're not able to pay your LFOs at this time. There is a guideline for a finding of indigency, and you'll see it down here where it says 125% or less of the current federally established poverty level. I'll talk to you guys about that right now real quick. You can just you can just Google or search the federal poverty level at any time. The best website for it is, let me go ahead and switch over here. Best website is the healthcare.gov, which is the first result on Google as well. And it'll pull up the federal poverty level for your 2022 income and for your family size as well. So if you have a family of 4, your federal poverty level is 27,750. And if your income is less than 125% of that, and I'm sorry, I don't have the math on best. I went to law school, so I didn't have to count. But if your income is less than 125% of 27,750, then you qualify as indigent, and the argument stops there. But there are a number of other ways that you can be found to be indigent. And I'll go through those here. So the declaration starts with, I am the defendant in the above action and declare that I've been released from total confinement on this matter, which means you're not in custody anymore. And it means that you're also not on supervision. You have to have your supervision terminated as well. So the first part is I have paid my restitution in full. It's only if it applies. If you haven't paid your restitution in full, you're still eligible for this petition, so you don't have to check that. But if you have paid your restitution in full, certainly do. And then the next box will be I am indigent because, and that's where we can put a checkbox in, and it'll give us the different categories of what can make you found to be indigent. The first one is if you're receiving certain types of public assistance. It could be temporary assistance for needy families, age blind or disabled assistance, SSI, SSDI, pregnant women assistance. The list is right here, but it could be any form of public assistance that you can also list out over here. The court can look at it and make a determination on whether or not any additional forms qualify, but I've hardly seen courts argue on this issue if you are receiving public assistance. Another option is if you are involuntarily committed to a public mental health facility. And again, you're only checking the ones that apply. Not all of these apply for everyone. So you just check the boxes that do apply to you. This could be the federal poverty level that we discussed. If you're receiving an annual income after taxes of 125% or less of the current federal established poverty level, you would check this box. And this is often the most common box. This and the public assistance boxes are often the most commonly used. And then the next box will be if your income is above that 125 level, but because of recurring basic living expenses, you're unable to pay the LFOs imposed, you can still check that box as well. So if you're a little bit above the 125%, but because of all of the bills and legal obligations you have outside of the court, it makes paying the LFOs financially difficult for you. You can explain that section right here for the court as well. And then there's even a box for any other compelling circumstances that describe your inability to pay. One other option is if you are homeless, you can select the box right over here. And then the next one will be, I am not able to complete community restitution hours. And that goes back to if you're asking to convert it into community restitution. Generally, I don't fill out this one at this point either, unless I'm asking it to actually be converted for some reason. And then the last box will be, I have not paid my LFOs in a timely manner. However, my late payments or failure to pay was not willful, which means you weren't trying to escape your payments. And you essentially check that box and just say, I've had financial difficulties paying off my balances. You don't really need to explain anything more other than you've had financial difficulties. No need to explain what those financial difficulties are. You can flat out just say, I've had trouble paying off my balances. The last box is optional, as it says. If you have been able to contact the clerk and secure a financial case history, which is something the court can print out for you. Some courts make you pay like 50 cents a page or something like that. Some courts will just print it out for you. But if you have, generally they're only about 4 or 5 pages long. You can attach your financial case history from the court clerk as well. The last section right here will be you're requesting that the court rule without a hearing. That's basically the court just make this decision without a hearing, but you can also always request a hearing by telephone, video conference, or an in-court appearance if there's something you'd like to explain to the court as well. And then the last part, you just explain the date that you'll be delivering this to the court and to the prosecuting attorney. Always check with the court that you're contacting when you're turning this in to make sure that they automatically serve the prosecuting attorney, because if they don't, when you're at the courthouse, if you're handing it in personally, just run it over to the prosecuting attorney's office as well. And if you're doing it online, it'll be able to serve both the court and the prosecuting attorney. And then finally, you go ahead and sign at the bottom here for your city, state, date, your signature. If you've had counsel or an attorney help you here, they can add their information over here. Once that's completed, you're ready to turn that in. I generally like to convert these Word documents into a PDF if you have that capability, because then it makes that PDF not editable for anyone moving forward. So if you're submitting it electronically, usually it's best to convert it into a PDF if you have that capability. But if not, and you need to submit it as a Word document, that's not a problem. Once you have that completed, we can talk about the proposed order as well, which is pretty quick and not much information you need to share there. This is what the proposed order looks like, which is you can also turn in with your petition. Like I said, this is not required. The court can fill this out on their own, but it's generally just a nice way to tell the court you're helping out just as much as you can. And the only information you're really going to fill out here is the Superior Court and this county that you're at, then your name and date of birth and your cause number. And that's it. After that, the court's going to fill out everything else here based off of what the court finds. This is the order that will be returned to you, and the court will have selected what they have found and what they order to be waived and remitted. So oftentimes you'll find that the court will check off that you've been released, that you've either paid your restitution in full, or the court will check off that they find you indigent under whatever category or whether or not you're homeless. And then they'll find that your failure to pay was not willful. And those are the requirements for the court to have them waive your LFOs or remit any LFOs. The next part, the court will put out what they order. They'll, select if they're removing LFO interest, restitution interest reduction, or whether or not they're just remitting LFOs in all LFOs that are not restitution. But this is where the court will explain what they are reducing, what they're not reducing, what they're waiving fully, whether there'll be remaining balances. All of it will be listed right here. If you have an order that you don't understand and you need some help, contact any of the resources that we'll provide you here at the end. You can contact us at the Civil Survival Project and see if we can help answer any of those questions for you. And then finally, I wanted to go ahead and share those resources. So some of the ones that we had listed out here. Again, you can contact the Civil Survival Project. We have staff attorneys here, and pretty soon we'll have paralegals on board. So hopefully someone will be able to at least just answer a question for you if that's what you need. But either way, if we're able to help in any way, we'll try to. But some other great resources are also Columbia Legal Services. You can call them, make an appointment by telephone, or even try to come in at certain times. Washington Law Help is a fantastic website for a wide variety of legal resources and non-legal resources as well. So a lot, even myself still to this point, I go to Washington Law Help a lot to find just forms, information about courts, anything like that. And then you can also call the Northwest Justice Project Clearline and Center for Justice in Spokane. These are not limited to the only ones in the state. There are a wide variety. These are just some that we commonly work with and that we can list out to you. But even if we are unable to help you, hopefully we can refer you to someone else. With that, I will go ahead and stop sharing my screen. That is the presentation about the GR39 forms. And I'll see if we can move over to questions.
All right, Sugam, thank you. Charlie, appreciate you as well. Great job. I see Charlie's been answering most of the questions that have been popping into the chat. Does anybody have any follow-up questions? And I'm also monitoring Facebook for any questions in the chat there as well that I can upload.
Do you have any questions? Do you have any questions?
Yes, my question is this, sir. Back in 2019, the judge in Tacoma, Superior Court Judge Schwartz, took and said, being that I'm on SSI, and I was told by all 5 doctors I can't go back to work because I'm a major liability to any company with any employees, even else. And the Judge Schwartz signed off on it. He said, you will not pay no LFO because I find that you proved your case. Well, that was all good and fine. The city clerk, Kevin Stork, took and superseded the judge and said, I have to pay the whole LFO plus the interest on top of it. And I even told the judge back in 2019, I make less, at that time it was less than $700 a month. And I'm on SSI, I get food stamps, and I can't even pay for my bedroom with that. I have no means, nothing. So I need major help. And I feel that Kevin Stork discriminated against a disabled person because I'm hearing impaired and I got massive disabilities and I need help. This is my ex-wife and she is like my ears because I don't know what it is with women's voice. I can hear them in children, but I just need this written off, sir, because I can't afford to pay this. Everything keeps going up. I can't even pay for my bedroom. I'm that much in debt.
Yeah.
And I don't have a family to help me. My family's gone. And I'm massive in debt. I can't even file bankruptcy. I'm that broke. Because by the time the payment, the end of the month, I have nothing left. So I'm asking, please show me sympathy and help me. Because I need to come into the court system to do this. And I know that's asking a lot. But being hearing impaired, I miss a lot of stuff unless it's right in front of my face.
Yeah, so thank you. So certainly, you know, a couple things. So with regard to your LFOs, you know, the interest and whatever interest is on those, if it's on non-restitution, it's mandatory that it has to be waived. So that is certainly something that is worth revisiting in the courts. As far as your SSI, because you receive SSI, the federal law has held that SSI and SSDI wages cannot be garnished to pay for LFOs, and therefore you are not, as long as you remain on SSI or SSDI, you are not required and cannot be forced to pay any amounts on your LFOs. That's just, I mean, and that is settled law. And so you are not alone in this situation where courts have not understood that. And certainly if the judge understood that, then the judge has the authority and not the clerk's office. But I do understand that there's sometimes a miscommunication of whose authority is binding in those situations. So that is certainly something that we help with. I do know at the moment we are at capacity for serving folks. It is something that's sort of our intake is sort of on a rolling basis. As we have capacity, we are trying to expand our capacity by bringing on new staff, but that is a process. That said, I would encourage you to do reach out to us. Perhaps we can help you in at least getting you the right information. Alternatively, if you are seeking counsel, you can there are great resources at Northwest Justice Project who are doing this sort of work, and our sort of sister organization called Way to Justice, which they're located out in the eastern part of the state, but they handle cases all over the state. Both of those organizations may currently have the capacity to help represent you. I will also add, as I mentioned in the chat, I don't know if you saw, but the forms, the GR39 forms are in the process currently of being updated to reflect the changes that will take effect next year through House Bill 1412. Some of those changes to the forms will also include, or we are working to get them included, a paragraph on the form that indicates I receive SSI, I am asking to be relieved from the obligation to make any payments. Okay, and so obviously I don't want you to have to wait another 7 months to do it yourself, but that change is coming to enable folks to take care of this on their own, to make sure that is noted. I mean, even under the current forms, that's something that I would advise getting an attorney's help to make sure the language is right, but that's something that can be added onto the current form that says there's a paragraph for other where you can fill in, and it's the law is clear. Your wages cannot be taken from you if you are collecting SSI, and you are basically you're in a sense judgment proof. You can't wring blood from a stone, right?
Yeah, that's an old saying from my grandmother.
Yeah, well, I'm getting longer in the tooth, so I'm trying to adopt more and more old phrases. So all that said, please, I'm happy to provide whatever we can provide you whatever information we can. We don't currently have the capacity to take on representation likely, but there are outside resources, and you are 100% entitled to relief here.
And what was that one called? We the Justice?
The Way to Justice.
The Way to Justice. Okay.
And I'd like to thank you and thank every one of you guys, because you help us out. I would really love to go back to work if my doctors would allow me. But being they put it to me that way, they said, you're a major liability. And I don't want to put nobody's life in jeopardy. I have enough problem with my own life.
Yeah. Thanks for uplifting that, Mark. And these fines are such a huge problem for so many people. I was just trying to think, Charlie or Sugam, what should Mark's first step be? Should he maybe if he's able to go to the county clerk's office where his charge is from. And, you know, I know some counties have been really helpful and some not so helpful. Would you advise him go and ask the clerk if they have a packet or anything like that?
Yeah, I mean, certainly, like Charlie mentioned, Mark, some of your LFOs sound like they are eligible to be waived at this time. So the first step would necessarily be, the best one would be to contact the superior clerk
Okay.
at that court and see if you can obtain your financial case history and look at beginning those GR 39 forms. We'll get your contact information here as well, so we'll try to keep in touch with you and see what we're able to do to help.
Yeah, I'm gonna have you call her, because if you call me on the phone, I'll be in la la land because I won't be able to understand what's being said.
No worries, we'll work it out.
Yeah. And as I told the other gentleman, thank you. And thank you for your patience.
No worries.
I see Patrick has his hand up. Patrick, come on in.
Yeah, can you hear me?
Yeah.
I guess I'm sort of twofold on this thing. So this was something that should have been done during sentencing, right? This is something that should have been done either during sentencing or prior to sentencing. As the attorney's duty, right? His obligation, his fiduciary, whatever, yak, blah, blah, blah. Okay. What I noticed that with a lot of these issues, that it's just not being done. So for example, in my case, my attorney was paid $10,000. The court signed the voucher for his 10 grand. Okay. And obviously he didn't do his job. But instead of the legislature or the judges saying that, you know, hey, the reason why we're having this problem is because these guys just ain't doing their jobs. My unfortunate circumstance began in 2003. So I'm pushing somewhere around 100 grand. I might be $80,000, $90,000 into this thing right now, simply because my attorney did not do his job. But no one wants to admit that the attorneys are not doing their jobs. The judges will not admit it. No one seems to be interested in articulating exactly what is happening in our society. And it's not just Washington. So I'm not just ragging on Washington attorneys. I noticed that this is a thing like all over the country. None of these attorneys are doing their jobs, but they are being paid. Would you be willing, are you willing to help us flesh out the nature of this problem? Because all of the fancy language ain't gonna help. All of the, you know, no matter what legislation is passed, at the end of the day, you still have citizens being dragged into these courthouses. They don't know what's going on. The attorneys won't tell them what's going on. The judges won't tell them what's going on, other than, we're going to take something from you today. And there's a lot of agreement about what all is going to be taken. But no one seems to be able to do anything that will benefit these poor, helpless schlubs who are being dragged into these courthouses. I mean, what is the problem here? You guys are supposed to be the keepers of constitutional interests, the rights of the people, but instead you've become just a tool for facilitating judicial process, which is then used to bash the hell out of people like me. I mean, what's really going on? You guys are all in bed together, but you're doing nothing to help this society, period. And I'll leave it at that, man.
We appreciate that. You know, I understand your sentiment. We appreciate the way you feel and sharing that with us. You know, all I can really say is we are limited to what we're able to do, what we have the capacity to do. We're not attorneys that are in the courtroom for the sentencing. We are handling these cases post-conviction. So we are kind of focused on post-conviction relief here. We're happy to have a conversation and see if there's anything we can do for you here. But we are very specifically limited to post-conviction relief. There's not much we can do while a case is being sentenced. I understand your concerns with the criminal injustice system. I agree with many sentiments there. But unfortunately, we're here dealing with cases afterwards and trying to clean them up. And that's kind of what we're here to do.
Yeah, I would just add to that a lot of what we're doing is cleanup from laws that we've worked to change, and where the results of the change of those laws isn't automatic. So we need to go in and help people to clean that up. But I will vouch for our staff attorneys. They definitely care, and they're definitely working to undo some of the collateral consequences that have come with our convictions. Do Charlie or Sugam, do you have anything to add to that?
No, you know, I mean, I think, you know, unfortunately, our criminal legal system has a lot of holes, and some of that can be, you know, a large percentage of public defenders' offices throughout this country are overburdened, and it can lead to, and it can lead to situations where, you know, it just feels like everyone is, including the attorneys, are just getting, you know, they're just on a conveyor belt for the ride, and the ultimate losers in that system are the folks who are facing the criminal charges, and have to do the time and serve the sentences. And it is, I will just, you know, from my experience, public defenders are, the vast majority that I know are putting, you know, giving all of themselves to their work. I can't really speak to private defense attorney, the private defense bar, but I would imagine, I would hope that they are putting themselves into their work as well. Unfortunately, the system is designed to chew up and spit out people of color, people in communities of high rates of poverty, people with disabilities, people in LGBTQ communities. That is the system working the way it is designed to do, and it is something that we work here in chipping away at as best we can. And we as an organization are primarily focused on chipping away at the laws that keep people down once they're out, right? We're not frontline defense attorneys or staff. We are working on the back end in many ways, but we're also trying to do upstream work and contribute to system-wide changes that will hopefully not only result in less people. You know, the end goal is that we have less clients to serve, right? We'd prefer to be, you know, really struggling to find folks who need post-conviction relief. So we are not satisfied in this system continuing to work the way it is, and we are constantly working to change that. So I'll just add that.
All right, I appreciate that from both of you, Charlie and Sugam. Back to LFOs and getting relief for LFOs. Let's see, I'm checking the chat here. Looks like Charlie's been doing a really great job of answering questions in the chat. Let's just uplift one for people watching on Facebook. Suggestions on how folks can deal with other state agencies like DSHS trying to garnish wages for restitution, even though folks are making payments. It looks like Charlie suggests forwarding a copy of the order to the state agency, which should make clear the restitution process. In addition, as of 2023, restitution owed to state agencies will be eligible for a waiver. It looks like Chanel's done that numerous times, and they don't care.
Yeah, sorry to interrupt, Corey. I mean, I feel you, Chanel. You know, this is a problem with, again, it's a system that's built to fund, you know, different services are funded through the operation of the court, and therefore those systems revenue streams are dependent upon they're dependent upon the indigent folks going through the court system to finance them, right? So like the victim penalty assessment that everyone is assessed when they're convicted of a felony, that goes to fund victim services, which is largely victim services and like victims advocates within state prosecutors' offices. There is no reason why that system should be funded by folks who are going through the court system. There are better ways to finance that, and we as an organization are working to you know, change the laws so that they reflect that reality. That said, you know, many municipalities, many counties, many state agencies are in some way reliant on monies that are coming from folks who are convicted of crimes. And you know, it's just everybody's trying to get their piece of the pie. It's, you know, you run into it a lot with like state clerks offices who you know, some clerks offices don't send their fees out, their LFOs out for collections, but instead serve as their own collections agencies and therefore charge collections fees for their services. Well, the idea of charging collections fees on an indigent client makes absolutely no sense. But at the same time, the clerk's offices are not interested in that argument. They are interested in paying for their own operation. It's just a matter of, you know, bureaucratic balancing. So you know, the one thing you have on your side is a court order, which states specifically how things are going and things are meant to go. So you've got that, and that is the rule of law there. It doesn't help solve the harassment issue, and it is a complicated system. But I do see, Chanel, you do have your hand up, so why don't you go ahead?
Yeah, I just want to say quickly, I totally get that and all, but the issue is that, like, you know, like, we don't have a unified court system. Agencies don't talk to each other. Well, the clerk keeps telling me, you know, you have this court order, they can't supersede the court order. Nobody will call DSHS and tell them that. They keep telling me to say it. It's like, I have no, for lack of a better term, value with them. You know, my word doesn't mean anything. Then on top of that, they're sending what looks like legal documentation, which is just really a printout from Office of Financial Recovery, to your employer, and your employer thinks like, well, I got to do this because, you know, it looks, they're, you know, they're saying I have to do it. That is the issue. Like, how do we get them to talk to each other? Like, you can't. And then the court is also saying, if I don't pay them, then I'm not in compliance. So then what do I do? Yeah. So I'm not trying to, but I'm like, there has got to be something or some sort of solution, because I've been dealing with this for a while. Like, it doesn't make any sense. I'm like, for y'all to complain that I only made 3 payments in 2020, I'm like, my God, we were in a pandemic. But I have been making payments since then, you know? Like people's rent is going up. I don't understand why an agency, DSHS, that is supposed to be helping people is willing to put people out on the street. Because a garnishment is what, 25% of your income? Are you serious? And what's going on right now? That, and then I've even submitted, you know, wax RCWs that says they can waive it. If they can realize that you can't pay it off in 3 years, they could waive it. They won't.
Mhm.
There's also a whack that says if it could show that it will cause you a hardship, they could waive it. They won't though. So that's the thing. And then getting just the two agencies to talk to each other. So I'm like, that's my only thing. Like, what is the suggestion for that? I get it. The law's on my side. I've done everything you've said, but really until somebody in a position of power says, y'all got to do this, ain't nobody listening.
Yeah.
Thank you.
Yeah. Thank you for sharing that, Chanel. And I empathize. It's not, and I wish I had a simple answer of, oh, well, here's a designed process for getting agencies to speak with one another.
Right. And I'm actually very somewhat savvy, you know, my background, but I know folks are not as informed as I am. So if I'm somebody who is this informed and I'm having this much trouble, imagine what other folks are going through.
Right. Yeah. And I will say, you know, that work is being done. It's not a speedy process. You know, bureaucracies move slowly to begin with, and on top of it, you know, you add in the legal system outside of the bureaucratic mechanisms, and you've got more complications. But that work is being done. You know, and an example of that is 1412, which will make those kind of that kind of restitution eligible for complete waiver, right? You know, trying to avoid. Yeah, I hear that you can't wait either. You know, and I go ahead, Sugam.
Chanel, can I ask, your order isn't restitution to DSHS, they're just garnishing your wages, right?
It's the order is restitution to DSHS plus overpayments from years ago. That's another thing. I don't even think they have the statute of authority to collect the debt. It's that old, and they're just ignoring it.
Yeah, I mean, there's certainly some strange nuances in this that I'd like to know a little bit more about. So let's get contact information from Chanel and see if I can, we'll try to figure out and see if I can run this through our team and see if there's any other information on if we were able to give you any advice at least.
Okay.
I can connect you guys. So this is Kelly.
Great. Thanks, Kelly. Yeah, I mean, honestly, I understand all of your frustrations and I know that you don't have the opportunity to wait either. It's just, sometimes there's these weird nuances that require at least a deeper look or something to see if we can at least try. But I want to know what it is that if the court is telling DSHS that they can't garnish, why they feel like they can.
But they're not technically telling them they can't garnish. They're telling me that. They're not calling them or saying there's nothing formal being said to DSHS that they can't do that. Do you get what I'm saying? Like, it's just
failure of this ununified court system. But let's reach out and see if there's anything that we can try to get answered for you at least.
All right. Thanks, team. Let's see. Quick question in the chat. Someone was recently released. Let's see. Released. I was a minor when I did almost 12 years. I've been trying to figure out all of my LFOs. He's had conversations with the county clerk and learned that after sentencing, restitution was imposed. Had asked questions surrounding that as to how and why and how come I was never reached out to.
Yeah.
So it looks like LFOs or restitution was added after sentencing.
Levi, if I'm understanding this correctly, you were probably and then a restitution while you were in custody, and you weren't there for that hearing, and then restitution was probably entered. Does that sound right?
That sounds about right.
Yeah, I mean, so generally, just to touch up quickly about restitution for everyone, after you are convicted of a case, the court can do a restitution hearing to see if there's any sort of loss that needs to be appraised and sent out. You are supposed to be at that restitution hearing, or at least notified of that restitution hearing. But if you're not at that restitution hearing, the court can go ahead and enter in an order. It's a very frustrating process of the criminal justice system. It happens. But the issue that I'm seeing, Levi, is if you were not informed of your restitution hearing completely, it's a bigger issue on whether or not you had ineffective assistance of counsel or whether a hearing was conducted without your knowledge. That certainly is a rare opportunity, a rare chance to challenge your restitution. But what you're essentially doing is challenging the conviction, not the restitution. You're trying to overturn what I think would be going on in your case. You'd be looking back to see if you get a court hearing on that restitution. So if I'm understanding it correctly, it looks like there was an error at the sentencing.
Yeah, so I think so. Can you guys hear me? Yeah, so I was 15 when I went and I got sentenced, and then I went to prison, and I recently just got out. And I met with my probation officer, and she was trying to get all the LFOs lined up for me. And she told me to contact the county clerk. And I did. And so what she actually told me was that she told me everything I owed. And then she was like, oh, you have more. And then she said that they were no longer doing the interest rates or whatever. And so she deducted all that, told me what I owed. And then she told me there was more. And so from there, that's when I learned that after sentencing, they went on and had a hearing. And I think it was about 3 months later. And I asked why I was never notified, or at least told, like, hey, this is what's going on. And nothing. And so she was just like, yeah, I don't know why we did that, but we did.
So I would suggest, Levi, your first steps here would be, one, did you have a public defender or a private attorney?
I had a private.
Okay. So first step obviously would be contacting your private attorney to see if there's any records that he can give you, which he's required to give you, he or she. But also I would contact the Northwest Justice Project and see if they can look at potentially whether or not your case requires a petition to go back and look into maybe either look into overturn a conviction based off of ineffective assistance of counsel, or whether or not there's a chance that you'll be able to get a restitution hearing again.
Okay, thank you. I appreciate it. Thank you.
Great question. Thank you for that.
And again, for everyone, this is something that can happen. Oftentimes when you are sent away to DOC, often the courts will issue a restitution hearing, and there could be an issue with DOC transports or something that doesn't get you there, and courts are ruthless and just go ahead and have that hearing. So this is a scenario that does come up every now and then.
Hey, real quick, may I ask another question to follow up on that? Yeah. So I was wondering, so technically, did they break the law? Because I did ask, and when I went through my JNS, and it does say to be determined, but after sentencing, my counsel wasn't there when I met with the clerk. And mind you, I was 15. And so when she came and I signed those papers and I did my fingerprints, she said, this is all I would owe, nothing else. And then when I called a couple of days ago because I actually did see counsel and I asked for some opinions, and then they told me to go ahead and call back and ask these questions. And I did. And the gal was just like, she said, no, we're allowed to do that. She's like, but I don't know why we didn't contact you. So she pulled it up and it said to be determined. And she said that I had checked the box saying that I didn't need to be present. And I asked her, I said, well, I don't remember that, and I was 15 then. So for that to occur and I didn't have my attorney there, I was like, and to be told that this is all I would owe, and then come to find out I owe more than that.
Yeah, I think, Levi, your case certainly might need a deeper dive into transcripts and whether or not if you were ever informed. So yeah, I mean, I think certainly there's a chance, opportunity, or you should contact the Northwest Justice Project to get started and see if there's either they can help you or if there's any resources they can help look out for you. But I think what you'd be looking for is to see if you were not properly informed when you were represented by counsel.
Okay, thank you. I appreciate that.
I see a couple of questions in the chat that I'm going to uplift in a moment, but I just want to make sure and make space if any folks have questions specifically related to getting LFO relief for themselves before I uplift or dive into a different conversation.
Yeah, and I just want to point out for everyone, we understand your frustrations with the system. It's the reason that all of us here, Corey, Charlie, all of us got into this work. It's the reason most of us go to law school here that are working on post-conviction work, is because this is such a depressing and unfair system, and we understand that. I think one expectation we have to try to keep in mind is we're not able to fix that, all of it overnight, and just, it'd be nice if we could, but we're unable to. We can really just handle what we're able to and what's in front of us. Specifically, these LFOs that are really weighing down on people. It's a huge burden. It's a huge weight on people's shoulders. And it's kind of one of the focuses of our work and what we're doing is to try to figure out how we can unwind a lot of that oppression that has already occurred. But I understand that oppression has occurred and it's traumatic and it's painful. And so a lot of our job now is to try to unwind that.
Yes, and we are definitely uplifting the issues of the court systems as we're going along and trying to get relief for folks, to people in positions of power. But it's definitely a slow process. Okay, let's see. I see a restitution question. A private attorney informed them they wouldn't need to go to the restitution hearing because the claim being made was not going to be valid. Then the claim was validated at the hearing, which is a situation in which a petition for another restitution hearing could happen.
So let me just clarify if I could. When I was talking about a petition with Levi, it wasn't a petition for a new restitution hearing. What essentially we're talking about is a petition for what's basically an appeal, that you weren't properly advised at the time of your conviction. Yeah, I don't know of a way to get a brand new restitution hearing once the restitution order has been entered.
Thanks for that. Charlie, I was wondering if you could quickly, I know that you practiced law in Colorado, and I believe they have a unified court system.
That was me.
Sugam was in Colorado. I was in New York. I was in New York. That's all right. New York also has a unified court system. Yeah.
Okay, would one of you mind just kind of briefly sharing the difference and how that affects?
Sure. And, I think when we're saying unified court system, it kind of sounds like a governmental process that we're discussing. But essentially what we're talking about is whether or not there's like a online system, a website, a court process for the entire state to run together. So for example, in Colorado, there was one website to file every motion for every different jurisdiction and one website to download every motion and all of the documents in a case for every jurisdiction. That is a unified court system, and it's more of a luxury than it is a constitutional requirement, unfortunately, which it should be. But nevertheless, it's an issue of state resources, government funding, and whether or not the courts have the capacity to implement something so technologically complex. So yeah, like Kelly mentions, one-stop technological shop for all court records. Not all states have that. Even California doesn't have that. Washington doesn't have that. Oregon doesn't have that. It is a luxury that comes for not only just attorneys, but the people itself. But it's an issue when you don't have a unified court system like we're seeing. We don't have courts talking to each other. We don't have departments talking to each other. We don't have an ease of a process. The state now has to create a GR39 form to try to make it easier. But it's just not the same process throughout the state. It would make so much sense. It's common sense. It's what you should have, but unfortunately, it's just not here. And so that's what we mean by unified court system. It would be great if we had something like that. It would make a lot of this work easier, and it makes some of these issues go away. But we don't have that in the state.
Okay, and then let's see, Patrick, I see your hand.
Yeah. So on the subject of the unified court system, you said something very interesting, and I didn't want to lose track of it. You're saying that it's not a constitutional guarantee, okay? However, there's a problem with that, right? What's the whole point of a civil servant, right? Only if we say that these people's job does not involve protecting the citizens. If they're up there for no other purpose than to protect themselves and to protect their friends and whatever the hell they're doing, then it makes sense to say that a unified court system is not a constitutional guarantee. If we, the people, hired these people to serve the masses, then it becomes a lot more difficult for them to get away with all of the nonsense they've been on for the last 150 something odd years, right? Unless we're saying all of this stuff, but we really don't mean it anyway. That's one thing, right? If we really don't mean it as a society, then that's something that we have to come to terms with. All of this shit that we're saying is just a bunch of bullshit anyway, and we just say it so we can pound on motherfuckers that we don't like, right? That's sort of a thing, right? If this is just a bunch of nonsense that we're running game on somebody so we can fuck them up and take their stuff, if that's all we're really doing, then I think it would be healthier for us as a society, for us as a collective, to admit that, you know what, the whole idea is just a bunch of bullshit, and you can do whatever you want as long as you got the army man to do it with. You know what I'm saying? As long as you got the manpower and the weapons, you can do whatever the fuck you want, right? All of this other shit is just a bunch of bullshit. Constitutionally speaking, their obligation is to the public at large. So if that is their obligation, if that is their duty, then they are engaged in treason by not using all of that education they have, all of that Ivy League study they have, to introduce a unified system by which the people can effectuate our purpose as a society, right?
Yeah, Patrick, I agree with what you're saying. The system's definitely built to work against us. And you know, we're working against you know, over 400 years of policies and laws that were designed to keep people down, and especially people of color. And I also wanted to uplift, I believe, as we were, and please somebody correct me if I'm wrong, but as we were looking into the unified court system issue, there were some, it's going to be difficult to change because of our state's constitution, and I might not be 100% correct on that, so please don't quote me, folks. But is that
so each
right?
each court is required to have that access for anybody that's involved in that court system. You have the right to go to each court and go to each clerk and ask for your information. Those are certain rights that are protected. Just unfortunately, there isn't one that mandates that all courts have to have a database together. Each court has to have their own, certainly, but unfortunately there isn't any mandate.
Yeah, and I'm seeing that we're down to our last 8 minutes of this event, so I want to circle back to questions around relief for LFOs and folks getting direct relief, and also remind folks watching the live stream that you can ask questions in the chat there as well. And I also want to remind folks that we are streaming live on Facebook, so try and watch your language a little bit. I think Facebook tries to censor it, the swear words, but I'm not sure how good they do. So any more questions about LFO relief today? All right, I want to remind folks that you can reach out to us anytime. I put my email in the chat, Corey Walster at civilsurvival.org. We've also got a new website that we've just launched. We're still working on building out some of the resource pages, but we've released the new site. Feel free to email me if you'd like to, for any reason, and we can set up one-on-one meetings. Feel free to check out our website and our contact us form. And if no one has any other questions, we can. Appreciate you too, Chanel. Appreciate everybody's questions. All right, have a great day, everyone. Enjoy your Saturday. Charlie and Sugam, do you have anything to?
Really quickly, I do see one more question from Wendy here. Pierce County had an event for LFO relief. Is that a recommended course for other counties? Yes, Wendy, that is something that we are constantly working on with other counties and stakeholders in trying to organize those mass relief events, because they are an effective way to really get a lot of relief for folks. And you know, certainly with LFOs, it's a process that lends itself to helping a lot of people at once. So we are, you know, it is our part of our plan and vision to help coordinate and host those events, at least you know, ideally a couple times a year. We are in talks currently with possibly helping out in a similar event in Thurston County. For, you know, that's on the, you know, fairly near future horizon. So that is something we're working on, and yes, those events do make sense. So we're hoping that.
I think if you're talking about the Pierce County event last spring, that was done, but we put on that event with Pierce County as well, and we're definitely looking at holding more of those.
But thank you all.
How do we go about giving you contact information?
You can go to our website, or you can email me, Corey Walster at civilsurvival.org. I put both of those in the chat. We've added a new contact us form to the new website that really makes it easier to choose what you're reaching out to us for. And as Kelly said in the chat, we also have a Monday night statewide, what we call Game Changer group. It meets every Monday night at 6:30 p.m. and we dive deep into reentry issues. Like, we dive deep into legislation and learning about that and how bills become laws. We dive deep into supporting each other and building community. And it's just a really great space for formerly incarcerated people to gather and build our collective power. Yes, as Kelly said, COVID's made it challenging with the mass assistance days, but we did one in September in Kitsap County, where we were able to help around 250 people with over 1,000 cases get relief from LFOs or records vacated. We did an event in Pierce County a few years back where we helped 750 people get relief from LFOs. We did an event in Kitsap County a few years back where we helped 500 people get relief from LFOs, and the courts have forgiven around $10 million that we're aware of. And a lot of that was pulled back from collection agencies. So we see that the need is so great that the way we can help the most people is by doing these mass assistance days. but it's definitely been a process during COVID. So we're doing these events to teach people how to navigate the process on their own with a little support of their friends or come into a game changer group. We're working to have access to be able to help people by looking up their records, their history, so that they know what they need to get removed or work on. And I just want to share that, you know, I've been doing this work for about 6 years now, and along the process, I've slowly been getting relief from my LFOs or this or that. And as we've changed laws, it's made it to where I never would have been able to get my record vacated. But due to law changes, our time starts now from the time we're released or no longer on community custody. So it's not tied to our LFOs anymore, but we still need to pay those off to get our records vacated. And because of these law changes, we've made it to where people that were never going to be able to get their records vacated can get their records vacated today. So, you know, that's what we're working towards. It's not as fast of a process as we would hope it would be. I would say all of the time, not most of the time, all of the time, but we're working to improve that. Any last comments before we close out?
Yep, thank you very much.
All right. Appreciate you all. Hope to see you at a Game Changer group. Please email me. Please reach out to us. Please get on our lists. And because we're doing great things all the time.
Thank you all.
Thank you.